More on all this now. Let's bring in Jordan Seculo, Executive Director at the American Center for Law and Justice, and Bradley Moss, an attorney specializing in national security litigation. Good to see you both.
Happy to be here.
Thanks, Shannon.
All right, Bradley, let me start with you. First of all, we have Mr. Comey's explanation on why he decided to put this information out via a friend. We'll play a little bit from the hearing yesterday.
Really just a gut feel laying on top of all of that, it's going to be important to protect this organization that I make records of this, because it didn't dawn on me originally that there might be corroboration for our conversation, there might be a tape. And my judgment was I needed to get that out into the public square. And so I asked a friend of mine to share the content of the memo with a reporter.
And there are some serious questions about that timeline. We won't go to that right now, but the question is this. If those documents, Bradley, were created while he was a government employee using an FBI laptop, he talked about doing that, are these government documents, did he have a right to release them even though he was a private citizen once he did the release?
The simple answer is yes. There was no, in the sense of there was no criminal restriction that would have applied. Once he became a private citizen, the only way anyone could stop him from doing anything, the only criminal provisions that would apply would have been if he was releasing classified information. As far as we can tell, the memos themselves are strictly unclassified, so there was no restriction on his ability to share it through the friend to the New York Times. There are, of course, ethical concerns and civil liability concerns he had to take into consideration. Arguably, he was quite possibly violating executive privilege by exposing the memos, but given the extent of the president's public comments, both to Lester Holt and through his tweets, I think it'd be a pretty significant stretch to try to make that argument for a state bar.
Jordan, what do you think, either Mr. Comey or the friend who served as the conduit to the press?
Yeah, they're in serious legal jeopardy, and it has nothing to do with classified. It has to do with exactly what Jim Comey said, which was it was a record. It was an official government record, and there's actually a criminal code about that, and it has nothing to do with classified documents. It's 18 U.S.C. 641. People can look that up on their own, but it says that government officials, which he was when he wrote it and when he took the memos with him, cannot take government records, convey them to someone else without authority, and that's it. That's a crime, just conveying it without authority. Now, it could be a felony depending on how they determine value, but the courts have said intangibles count under this statute. We actually have prepared what a draft indictment would look like of Jim Comey. Doesn't even get into the Privacy Act concerns, the executive privilege issue. Just taking government records is illegal. They don't have to be classified.
All right, and prior to this yesterday, where we got the stunning admission from the former FBI director, just almost in a nonchalant manner, that yes, I leaked these out, the focus was on whether the president would be in any trouble, obstruction of justice, or other issues. Here's what his attorney said following the hearing.
The president never, in form or substance, directed or suggested that Mr. Comey stop investigating anyone, including the president never suggested that Mr. Comey, quote, let Flynn go, close quote.
All right, Bradley, I'll give you the first bite at that. What do you think?
Well, now you've got the sworn testimony of the former director of the FBI who'd served under multiple different presidents versus the unsworn, grammatically riddled statement of the president's private attorney denying it. One person's under oath, one person's not. So if this is going to go away, if this is ever going to be investigated by the special counsel, you're almost guaranteed at this point that the president's going to have to be deposed under oath by Robert Mueller to address whether or not he said or didn't say what Director Comey, excuse me, Mr. Comey, has alleged that he said.
All right, Jordan, very quick. We got to move on, but quick final word from you.
Yeah, I think very clearly for everybody out there, saying that you hope something is not a directive. Jim Comey admitted under oath he wishes he was stronger. He didn't stand up. He didn't report this. You know why he didn't report this up the chain? The truth is, Shannon, he knew it wasn't necessary under 18 U.S.C. 4, which would make it criminal for him not to, because it wasn't obstruction. That's why he didn't report it up the chain, because he knew that wasn't obstruction of justice.
All right. Jordan and Bradley, some disagreement there, but two great legal minds. Thank you both for weighing in.